let us move on to slide number 10. Yeah, this is another important judgment, the Madras Fertilizers Limited case. I think this is very specific to Tamil Nadu, I would say, because this is a judgment given by Madras. I would say again, this judgment is not considered to be a very sound judgment, but it says that the gratuity is also considered as part of wages as the said term is defined under the current Payment of Wages Act. So, since it is considered as wages, if the contractor fails to pay wages, which includes gratuity also, then the liability goes on to the principal employer, right? So, which means again, if the contractor fails to pay the gratuity, the liability will pass on to the principal employer. That is the position currently. Of course, this is very specific to Tamil Nadu. Because if you go through the definition of the term wages under current Payment of Wages Act, some gratuity is included in the inclusion portion also, right? Certain gratuities are mentioned under the exclusion part. Fortunately or unfortunately, that particular judge, in fact, Justice Sirpurkar, he has brought this particular payment under the inclusion part, holding gratuity to be wages. So that automatically makes the principal employer liable to make the payment of gratuity in case if the contractor fails. So existing position is the principal employer is liable to the contractor fails. But as per the code, the gratuity is not included in the definition of the term wages. Very clearly, it is excluded. So automatically, even if the contractor fails to make the payment of gratuity to his workers, that is the contract workers, the liability will not pass on to the principal employer. I think again a big change in the current position. This may be more advantageous to the principal employers. Now I move on to slide number 11. The central government will fix the floor wages. The rate of minimum wages fixed by the appropriate government shall not be less than the floor wage. Of course, we are now aware that there is a concept called national floor level minimum wage. I think notification is issued by the central government periodically, but it does not have statutory force. Currently, it does not have statutory force. But in case if the Minimum Wages Act is not applicable to some of the industries or some companies, in fact, they follow the wages prescribed under as national floor level minimum wage as per the notification issued by the central government. This is there more as an industrial practice, right? This is not employers do not have statutory obligation to make this payment. Once the act is not applicable, then they are not bound by that. But as a practice, they resort to making payment at least as per the national floor level wages, which is fixed by the central government on a periodical basis. Now there is a change here. The government is giving kind of a statutory force to the floor wage. Now it is not called national floor level minimum wage. It is just national floor wages. This will be fixed only by the central government. Again, I repeat, the national floor wage will be fixed only by the central government, but the minimum rates of wages will be fixed by the appropriate governments. It could be central government or various state governments. The point here is the appropriate governments shall ensure while fixing the minimum rates of wages for any employment, right? It shall not be below the quantum fixed as floor wage by the central government. So indirectly, the statutory force is given for the concept of floor wage now. Again, the national floor wage shall be revised at least once in 5 years as per Rule 11.4. Of course, the rules are now given. It is only in the draft stage. It is not yet passed, right? So at least once in 5 years, this national floor level floor wage will be revised.